Good evening, ladies and gentlemen. I'm Sahana Pai. It gives me immense pleasure to extend a warm and hearty welcome to all of you for this seminar on Real Estate Regulation Act. This act is the most awaited and perhaps the most needed legislation of recent times. It aims to restore consumer confidence, to bring in more accountability and transparency by giving Indian real estate industry its first regulator. Will RERA do to real estate what SEBI has done to stock market remains to be seen. But what is certain as of now is the impact RERA is going to have not only on builders and buyers, but also on the legal fraternity. As advocates, it's therefore imperative for all of us to understand RERA. We, after all, live in a knowledge-based economy, and we cannot be truly successful unless we learn to assimilate and apply new knowledge. That's precisely why we've organized the seminar, and we are fortunate to have with us Mr. Anup Shah, who is a renowned advocate and a key speaker. I welcome you, sir. We are truly honored by your presence. We are also honored by the presence of Mr. Basavaraj, who is the managing trustee of Daksha Legal Charitable Trust and the driving force behind this seminar. I would like to welcome our dignitaries on the dais. I'd like to introduce our dignitaries. Mr. Anup Shah started his career in Mumbai in 1981 as a litigating counsel in the chambers of Mr. S.H. Doctor, a senior counsel. When he shifted to Bangalore, he joined as a junior to Uday Holla, senior advocate and former advocate general. He then took over the office of R.V. Ravindran, establishing Anup Shah Law Firm, which has offices in Bangalore and Chennai. Anup Shah Law Firm specializes in real estate transactions, advising developers and investors, both domestic and foreign, structuring development agreements, joint venture agreements, commercial contracts, company law matters, and civil litigation. Mr. Shah has been leading discussions on impact of Real Estate Regulation Act and the rules framed thereunder. He has been invited to respond to queries of general public by Times of India. We are truly fortunate to have him here with us. Our second dignitary needs no introduction. Mr. Basavaraj has over 30 years of experience as an advocate. He started his career under R.V. Vasant Kumar, who was later appointed as Judge, Karnataka High Court. He later joined the chambers of Shri S. Vijay Shankar, Senior Advocate and former Advocate General for Karnataka. He started independent practice in the year 1999. His firm specializes in constitutional law, corporate law, real estate town planning, municipal. He founded Daksha Legal Charitable Trust in 2016 with a vision to help and encourage young advocates. No amount of words can do justice to the amazing work that is being done by this trust. I would now like to request Mr. Basavaraj to say a few words on Daksha Legal Charitable Trust.
Good evening, friends. I don't know whether I deserve all the good words spoken by Ms. Srimati Sahana Pai. What happened is this. When I was with Mr. Vijay Shankar, former Advocate General, I used to make a lot of notes about the cases. So we used to write on a small exercise book. And thereafter, after a period of time, I arranged it in a chronological. When the internet era came, then what I used to do is the important judgments I used to email myself. Is an inbox. I would go through the inbox and I will find out the judgments. Then the era of Facebook came. Then I created a profile of myself and used to post the judgments in my own profile, and I would search the judgment whenever I found. Then somebody told me that you can create a group of people where you can share the data. So I first created the important judgments group, which was inaugurated by, simultaneously I created a website called www.dakshalegal.com. It was inaugurated by Honorable Justice L. Narayanaswamy in 2016. That day, the strength of my group was about 3,000. Today, it has reached 49,600 as on today. And in the meanwhile, I thought of giving back to the junior advocates who really require help and medical care. So I started this Daksha Legal Charitable Trust, and myself, I donated about 5 lakh and collected another 3 lakhs from the members. And what we are doing is, in case of a medical emergency, if they just give the medical certificate along with their ID card, we'll be releasing the immediate financial help to up to about 25,000 rupees. I'm glad to inform that the former Advocate General Mr. Ashok Arnoldi recently contributed a sum of rupees 1 lakh to the fund. And we have the request by the junior advocates are very less. Touchwood, I hope all of them are they remain hale and healthy. But the idea of the trustees to give back to the society in the form of knowledge, in the form of help, which is required by the junior advocates. We hope that our number of members increase and the contribution increase and the number of persons who require the fund decreases. So coming back to Sri Anup Shah, we used to call him as Mr. Richard Gere. So he is one. He's like what Bill Gates in the software field, in the field of real estate litigation and non-litigation sector. So it's a privilege for me to have a shared dais along with the greatest advocate on the real estate side. I request Sri Anup Shah to take over the dais.
I thank Daksha Legal for granting me this opportunity to discuss. I wouldn't say this is a lecture. I would rather say this would be a discussion between me and my learned friends who are here, because it's a very, very new act. As Suhana mentioned, that it's an act which was long awaited. It definitely was required, take into consideration several aspects, including the aspects of people who actually buy apartments, to bring in confidence in them to actually go in for their first apartments whenever they want to. Because what has been happening is, due to several aspects of the industry not being regulated, and I must tell you that this industry which we are talking in terms of real estate industry, it actually supports more than 250 ancillary industries in order to bring up one building. So this regulation was very important, I thought, and since the time the bill was floated, there have been several iterations. People have sent comments. In fact, the last comment awaited now is the agreement which has been put on the portal of RERA, which they want comments on, and I think every one of you here should contribute, and we'd be very happy that the contribution comes from our learned friends, because that gives a wider aspect to a document which probably will then be finalized for the state of Karnataka. What we have done today is, in order to give you a quick review of what the act is, we've got a small presentation here, which I'd like to run through, so that once we run through this, I know it won't be in great details, but it'll have some important aspects of this act and some part of the rules which have been notified on 11th July 2017. As you all know, that this act basically is to promote a regulated industry in a transparent manner, which would benefit not only the buyers but also investors who come into this field, and which will actually develop great amount of confidence in the society. Most of the, from my personal knowledge, I'd like to sort of bring it to the fore, is that most of the builders, at least in Bangalore, most of them have gone in for registration, and you will be surprised to note that Karnataka has the second largest registration under the Regulation Act, following Maharashtra. Obviously, Maharashtra is much larger, but I think we are the second largest. So you can understand that the level of confidence which most of the builders have placed on RERA is reflected by the number of ongoing projects that have been registered. What we'd like to do is, the first slide was basically is the object and applicability of the act, which we have tried to sort of summarize it to bring in accountability, transparency, ensure fair play, fast-track dispute resolutions, enforcement of contracts through a regulatory mechanism. As Ms. Pai mentioned, that what SEBI did and does in the stock exchange, and both are BSE and NSE, we hope that with our regulator also, we probably will have quick dispute resolutions, effective and also following the principle of natural justice. That's the basis on which the regulator will be appointed. Good governance applicable to the whole of India. It's not retrospective, because it's very important that we had a lot of queries which talked in terms of whether the act was retrospective. The act is not retrospective, it's prospective. So all the, as we understand, and I'm sure, this is something which probably you and me both will be learning in the process of time, because these rules are applicable since the last month, and the act is applicable 3.5 months back. So we don't have any set precedents, we don't have any rulings, we don't have any rulings from anyone, and we probably will be in the passage of learning. We will see what happens in the act. The act has tried to sort of define most of the aspects in the real estate, but we found that there were some important aspects and important definitions which are real estate, what a real estate project means, who a promoter is, who is an authority, apartment, carpet area, competent authority, local authority, what is a sanction plan, commencement certificate, occupancy certificate, completion certificate, common areas, force majeure, and association of allottees. Why this? We have referenced only some of these definitions is because they are very important. Because if you would notice, all these sales which were made prior to coming in, RERA coming into effect, were basically on super built-up area. Builders were not willing to give you what the carpet area was. Now the builders are by law required to show you what the carpet area of the unit which you are buying. So you actually would know what is the exact area which you are going to use, leaving aside what are the proportionate common areas, which probably was not transparent at all earlier. People didn't know whether it was 25% of their carpet area, 30% of the carpet area, and at times people were just being cheated on that aspect because the pricing would then be very high. The definition of real estate project has been expanded so that every aspect of whatever is real estate development has been reflected in this slide. And the idea here is to include every aspect of development so that anyone who this act applies both to residential and commercial. This act applies only in case where a person wants to sell. So in case if someone is doing real estate development which is commercial in nature but does not propose to sell but only lease, then he does not require to register under the act. The definition of promoter is now being very clear, and what they have done is that every aspect of the person who does business in real estate gets covered. So you do not have a position where someone can say, look, I am not a promoter because of XYZ. What they have done is they have defined a promoter, a person who constructs, causes to construct any unit, converts an existing building or part thereof into units, develops land into plots without structures, with or without structures, and are constructed thereon, that is the bungalow schemes, sells all or some of the units, whether with or without structures, if unit is in a plot, includes any development, and the other very important aspect, I think I'm sure everyone knows about it, but I need to emphasize this, is that it also includes any development authority or public body in respect of allottees of units owned by such an authority placed at the disposal by the government. So I would understand that we would have KHB who would be governed by this, we would have BDA governed by this, and any other authority which takes up any housing or commercial development for purpose of sale to either to any of the allottees or applicants, they would be covered by this act. So, lots of time we find, save and except in case of central government, state government. Here they have actually included even the government who's doing business in real estate. Includes its assignees or any other person who acts as a builder, colonizer, contractor, developer, estate developer, person acting as a power of attorney holder, and such other person who constructs any unit for sale to general public. Where the person constructing and the person selling are different, both are construed as a promoter who are jointly responsible and liable under the act. So what has happened, if you look at this part of the definition, it actually encompasses, I think, everyone who probably takes up development. Allotee is a very simple definition. It includes the first time who makes an application, also includes a person who is an assignee of the applicant, but it does not include anyone who takes it on rent, as I mentioned earlier. The apartment is now defined, which tells you what would be covered by this act. If you look at the cover which they have given, it takes as referred as block, chambers, dwelling unit, flats, offices, showrooms, shops, godown, premises, suites, tenements, by any other name, separate self-contained part of an immovable property, including one or more rooms, enclosed spaces, located in one or more floors in a unit, used for residential, commercial use, such as residences, offices, shops, showrooms, and godowns, for carrying on business, occupation, profession, trade, for any other ancillary use. So if you notice, every aspect of the development has been covered by this definition of the apartment. Carpet area has been defined. So, this is slightly different from the notion we have about a carpet area. The carpet area here that has been defined includes the internal walls, which are part of the building, which earlier, if you look at the NBC definition, they are not included. Competent and local authorities has been defined, so that's our regular authorities. Sanction plan and commencement certificates, they have defined what sanction plan and commencement certificate. No project can be registered till such time as the commencement certificate is issued. We await some clarification on this commencement certificate as to whether it is just the plan sanction or the commencement certificate, which is understood by us in our terminology, because BBMP requires some aspect of construction to be completed before a commencement certificate issued. There has been some discussion on this, and we still don't have clarity as far as whether they can register the project at the stage of commencement certificate or at the occupation stage. Occupancy and completion certificate is a standard definition which is available in both the acts, that is your KMC Act as well as the Municipalities Act. Common areas have been defined so that anyone who wants to take an area which is any apartment, he is fully aware of the fact that this is the common area that would be applicable to his apartments. This is something very different from the normal definition of force majeure, which most of us in the industries would consider, because what has happened is the definition of force majeure has now been made within this purview of these slides and this aspect. There is no force majeure event which can be considered to have occurred in case of governmental delays or any strikes or riots, which probably is something which most of the industry experts feel that they may have some kind of issue, because there is always in our country some kind of delays which occur due to any strikes, riots, lorry strikes, etc., but that has not been covered. Maybe the logic is that, look, the force majeure event is basically something which should be by natural calamity, and that's why this definition has been really a restrictive definition in our view. Anyway, probably with passage of time, let's see how this works out, because I'm sure people will be questioning, challenging these in courts of law, and we'll have some kind of precedent on this. The definition of association of allottees has been given because for the specific reason that sometimes what happens is lots of investors get together and actually are one unit, and they book several apartments in a project, and then when the issue of NOCs, etc., come about, they want to ensure that such people who are actually together, who are like family members, associates, affiliates, etc., should be counted as one vote for the purpose of no objection, which we will see later on, which is coming about from the point of view of any change or amendment to be made in the common areas or the plan sanction. You require 2/3 of the majority of the people to whom they have sold. And that's why I think probably that was the logic to say, okay, look, if there is a conglomerate of people who buy units, they should be considered as one single unit. This is the requirement for registration. This typically is to give, when you go for registration of your project, means when you apply, you need to give all the details, which includes your details of the promoters, past experiences, photographs, your plan sanctions, etc. The only exemption which is available under the Act is that if your plot is 500 square meters and less, if you're constructing apartments not exceeding 8, you've already received completion certificate, redevelopment of the project with no new allottees are to be made. That means basically it's repairs, renovation and repairs not involving marketing, advertising, selling or apartments. Exclusion of ongoing projects are provided in the rules, because we'll come to that, because that was the aspect which probably each state, if you would have noticed in your newspapers which keep coming, that the act is being diluted, because several of the states have made rules where they have tried to exclude some of the ongoing projects. Even the Karnataka government has also given some exclusions from their ongoing project, which we'll come to it shortly. The exclusion which have been provided in the rules is where the layout has been completed, whereby all the civic amenity sites all civic amenities are completed, and all the common areas have been handed over to local authorities. Then it will be considered as not an ongoing project. As far as the apartment building is concerned, common areas and facilities have been handed over to the registered association of the majority of the allottees, 2/3. That means probably most of the apartments are sold. All development works have been completed as per the Act and certified by a competent agency, and sale lease deeds of 60% of the units have been registered and executed. This has been provided because there are several of our buildings, where probably the completion certificates are not there, but the builders have, handed over the common areas, sold 60%, sale deeds have been executed and registered. So not to clutter the entire registration process, they've excluded this part. Like, for example, there are lots of old buildings which probably may not have a completion certificate, occupancy certificate, but have been in existence for 5 years, 10 years, and that they have sought to exclude from here. As far as the ongoing projects are concerned, some of them which have got those who have applied for the OC, they are to be excluded, provided they have a certificate from the competent agency. The competent agency definition has been clarified in the rules by a clarification on 13 July, which says that any person who's authorized under Section 190 of the Municipalities Act 1964 could certify that this building has been completed and awaiting OC. And if there is a partial occupancy certificate, and that's also is covered. There are prerequisites for applications which we probably, sort of made a brief note of it, where the builder is required to upload on the site. I think this is not really important for us at the moment. Declaration has to be supported by an affidavit, which probably they have to certify that they have legal title, there are no encumbrances, estimated date of completion, 70% of the amounts realized to be deposited in a separate account, that they will deposit it, pending approvals if there are any to be taken that they have to disclose, and furnish all required documents prescribed by rules and regulations. These are additional disclosures for an ongoing projects which have been provided, which are the most important aspect which you must know is that what has happened is, as far as the ongoing projects are concerned, the authority and the Act requires a developer to bring in the amounts which it has collected, but it has not spent till the percentage completion provided under the Act. So in simple terms, it would mean that if a builder has taken advances from buyers and he has completed construction to the extent of, say, 50% of the amounts collected, then for the remaining 50% of the work, within 3 months of the Act coming into force, he would have to bring in that money to enable him to complete the construction. These are the fees to be paid. And I think not, I mean, luckily it's not very high. They have also got a cap, nothing is ad valorem. So as far as group housing is concerned, it's 5 lakhs. If there's mixed development, maximum 7 lakhs. Commercial project 10 lakhs, and plotted development 2 lakhs. And they've given per square foot also for the extent of what the areas would be. Uh, the grant rejection and extension of registration. The extension of registration will come in only after the registration is granted. But the regulatory authority, once it reviews your application, within 30 days' time, he is supposed to give you a certificate. If not, then it will be deemed as registered. If there is anything which is, and it's, I think, principle of law that if you do not give the true statements, it'll get rejected. So there is a rejection provision when it applies. The extension that has been provided is that once you give them time to complete the building, that is the time within which you are supposed to complete, and the registration certificate is valid for that period itself. So what happens is, once the time is getting over and you need more time, you'll have to make an application for extension of registration, and the extension of registration will be given for a maximum period of 12 months from the date which you have mentioned for completion of construction. The consequences of not completing, we will see later. I think that is the most important part, which probably we'll discuss. If the revocation of registration is to occur, they have to give you a hearing. That's principle of natural justice, and that's the process which we have shown here. The important thing which probably came about with this act is that any person who is going to be a developer has to be true to what he is promising. And what they have done is they have provided what would mean as unfair trade practice. And it is not only what you make a statement, but also a visual representation is considered as representation under this act. Now, why I emphasized visual is that lots of times you get brochures, you get hoardings, which probably glorifies things or promises things which probably are ultimately not given or not in the specifications in the list. So what they have stated is that not only will you give representation in writing, but you'll also give representation visually, which should be correct, and what you promised is to be given. As far as any violation of this unfair trade practice, will probably come to the regulatory authorities' rights or powers. If the revocation takes place due to you not having completed the project or the builder not having completed the project, the penalties seems to be strong, I feel, but I think it's an important deterrent because, as mentioned earlier, that most of the times there are people who put their lifetime earnings in this project, for buying an apartment. So what they have done is they have probably got a process of debarment. They will be listed as a defaulter with a display of photograph on the website. Freeze the project account, because all monies which come as advances are to be deposited in a project account, of which only 30% he can take, and 70% has to be released to the developer on the certificate of 3 people, that is the project architect, the chartered accountant, and the engineer. The chartered accountant cannot be the chartered accountant of the firm or an auditor of the firm. He has to be an independent chartered accountant who certifies the work having been completed to enable the developer to get the release of his 70%. They will inform all RERA authorities in other states as to the defaulting promoter. Remaining development will be taken over by the competent authority. There is a lack of how they will take over, but there is a provision that they can take over. The existing purchasers of the project will have the first right to get it completed. and the authority has the right to issue directions for the purpose of protecting the allottee's interests. These are some of the obligations of the promoter to the allottee, and this obligations, if you look at it, is basically to ensure that there is transparency, to ensure that no changes happen in the development, because lots of times what the developers were doing is that they would, when they get some additional land, when they violate, they will get additional FAR, they would make the change. But now, once you have registered the project, no change can be made in the project, save and except you get 2/3 of the people who have acquired to give an NOC. And that's the reason why the Association of Allottees I mentioned earlier, that they have, in order to ensure that there is no foul play in getting such kind of objections, those association of people will be counted as one vote, and the rest has to be the 2/3 majority. The exclusion of 2/3 majority for this is only applicable to ongoing projects, because what has happened is the act came in between. It is not retrospective; it's prospective. So, in order not to create confusions, they have given few alterations which is capable of being modified without the 2/3 majority, and you will find that these are the aspects which are covered for not getting the 2/3 majority. These are the obligations of the promoter. The most important obligation probably which we find, and which is very important that every person knows, is that now the defect liability period is not 1 year, or it is at the discretion of the developer, but the statute now provides that the defect liability period is 5 years from the date of OC. Now the defect liability also has been defined. They have expanded the definition of defect liability defects in the project, which is not merely a structural changes or structural defects, but also defects as to workmanship. If there is a real defect in workmanship also is now covered under the defect liability period. Within 5 years, if it is noticed and identified, the developer is mandatorily required to repair or rectify at his own cost. Any failure to do so, he will then be subjected to the provisions of the Act, which we will see later on, how the authority and the appellate authority have the right to. Now, this is the project account which the promoter is required mandatorily to have. Earlier, there was no accountability of the amounts which were coming in. The earlier concept, as I would put it in a very simple language, was that you take and construct. The aspect of take and construct seems to have now been reversed to say, please construct and then get your money. What they have done is that any advance which is paid, as far as the advance is concerned, any agreement which is executed, you can only take 10% advance. You cannot take 25% or what earlier they were taking, unless and until it's an ongoing project where you have reached a particular percentage completion, then you are entitled to take the monies till the percentage completion. Any amounts which are now taken as advance or otherwise as an ongoing project or a new project, 30% of the amounts will be, the developer will be entitled to take without any giving any accounts. 70% of the amounts will be retained in a project account. This project account also has to be disclosed in your RERA application. So this and project account cannot be charged, or no lien can be created on this account. So the 70% which remains here will be released to the developer once he completes the percentage completion which he has given in his schedule of percentage completion. And this amount will be released only after it has been certified by 3 members who actually will have to certify that A, he has spent this money, B, it has reached the percentage completion which it has been promised to be reached within that particular time, and see that the structure and the construction is as per what has been specified. And hence, we have three important people who probably have to certify. One is the chartered accountant who gives the account aspect. The other one is the project architect who probably gives you the aspect that the percentage completion is done. And the third one is the engineer who gives the aspect and who probably will have to certify that this is done as per specification and that it is true to the specifications given by the builder. And once that is certified, will the developer be entitled to 70%. So hence, when I mentioned this earlier, that earlier people used to take the money and then construct. And now It's the other way around. You have to construct to get your money.
And that's where the most important aspect and change I feel in the industry, because this was something which was never even thought by even builders earlier, and even those who really thought that this should be a professionally run organization. The other aspect is that in the RERA, if you notice that the developer has to upload his accounts every 6 months. It has to be audited every 3 months the progress report, every 3 months the completion report has to be given by the promoter, and it becomes public knowledge. And it will be available on the website of RERA, and in the RERA website, the developer website will disclose all these details. So any person who wants to buy at any particular stage of the construction can, very easily do that, and with confidence can go to the site and ensure himself that this aspect has been completed, and hence he can pay this money. They have defined land cost and construction cost, because this is important from the point of releases that have to be done
from time to time, that is the 70% and 30%. So they have actually given the definition and how to calculate the land cost. The land cost is to be calculated based on what you have purchased or value as per the guideline value, whichever is higher. This probably has been done to ensure that there are developments which happen based on historical lands. And if you take historical lands and today's value, then his receivables would not match to the pricing which he puts on the apartment per square foot. So hence what they have done is that if it is of present value in your sale deed, and if it is higher than the guideline value, you can take that. If the guideline value is higher, you are entitled to take that value for purpose of calculation of land cost. The land cost also includes if there is a TDR which is bought by the developer, there is any cost for NOCs, stamp duties, transfer charges, registration charges, conversion charges, taxes and statutory payments which you pay towards the land are also given as land cost, which actually is a very fair aspect from the point of view of the valuation of the land cost. The cost of construction which they have given has also been defined. All cost of construction, which includes on-site, off-site expenditures incurred at the project, includes payment towards taxes, fees, premiums, interest, etc. That is towards probably plan sanctions, etc. Includes all interest paid and payable to any financial institution, including scheduled banks and NBFC, because you are entitled to take loans, and based on the loans, construction loans, any costing which comes about for purpose of interest is also given to you. These are the process for registration, within how much time you have to register an ongoing project, which the time was given for 3 months from 1st of May 2017. Unfortunately, there was not enough time for lots of developers, because the rules in Karnataka came on 11th of July. That was around about 20 days, 18, 19 days. But I understand that registrations are being accepted, and I hope that the authority will definitely look at it more leniently to this aspect. Now this is, I think we discussed that as to how the amounts have to be utilized for the project, which I mentioned to you earlier, that you have to utilize it only for the project. If the promoter for any reason violates the aspect of withdrawal, because what has happened is the account which we are talking in terms of is not an escrow account, nor is it controlled by anyone, nor does it have any restriction. It's a self-imposed discipline on the developer to ensure that he does not violate. If he does violate, the penalties are huge. It could be 5% of the project cost, and it could go up to 10% of the project cost. And even the Act provides, which probably the compounding provision is in our rule, the Act provides for prosecution and even jail. Now, functions and duties of the promoter is basically to ensure that the building is completed as per specifications. He obtains occupation certificate, he gets water, electricity, and makes the unit habitable, is what has been now defined. He is also required to mandatorily take into consideration the fact that once the occupation certificate comes, he has to register and call upon the allottees to register the units. What had been happening was earlier, because of some reason, some payment of interest, some builder allottee fights or things like that, the builder had an upper hand to say, okay, I won't register and won't give you possession. Now I think it's become very mandatory that you have to give the conveyance within 3 months' time of the occupation certificate coming. Allottees are also to an extent responsible. Now if you look at it, the allottee's responsibility is very simple, and obviously it will be very simple because he has nothing to do save except pay the monies as per the installment which he has agreed to pay. So if he defaults in payment of that monies, there is an interest provision which has been provided, including the fact that the interest now is also regulated by this act. Earlier, there was no regulation with regards to the interest payment. There was an imbalance between what a developer would get and what the allottee would get. All these aspects have now been covered, and I think it's been put to rest. And whatever interest which the developer is required to pay, the allottee will pay, and what the allottee will pay is the developer is required to pay. And the interest also has been defined under the Act, and the rules now have mentioned that the interest would be 2% over and above MCLR rate of State Bank of India. So if you take the existing MCLR rate, it would be around about 11.5 to 12% of the interest that would be payable. Allottee's right to terminate. He can terminate the agreement in case of violation of the terms of the contract, not constructing. And if there is a delay, he has the right either to collect interest or to terminate. The termination process, if either being contested either by the developer or by the agreement, the purchaser, what has happened is you don't now need to rush to court because the civil court's jurisdiction has been taken away. And you can file your complaint before the adjudicator or the authority, which we'll come to because the authority is in the process of being set up, which will be set up in another 3 months' time. And the authority has to, within 60 days' time, adjudicate any dispute with a maximum further small period for which he has to give reasons. So what has happened is either which way, either the allottees or the developers have the right to go to the authority to adjudicate their disputes. These are the penalties which are provided in the Act. If you do not register the project, either new or ongoing, 10% of the estimated cost. If there is a continued default, imprisoned for 3 years, or further fine of 10%, or both. The compounding provision is not in the Act. The compounding provision is in the rules, which I will come to that compounding provision. Failure to make an application for registration, submitting false information to keep 70% in a separate bank account, 5% of the estimated project cost. And these estimated project costs can be huge so it's a penalty which probably, if you look at it, if someone asks me a question as to is it fair both ways, I would say, look, you have to look at it from this point of view, that the allottee cannot be penalized to such an extent because he doesn't spend that kind of money. The developer is more responsible for what he has promised, and hence probably the penalties are slightly on the higher side. If there is any contravention of any provisions of the Act, rules and regulations, up to 5% of the estimated project cost. These are small penalties which come about: failure to comply with directions and order of the authority, fine for every day's default, cumulative up to 5% of the estimated project cost, failure to comply order of the appellate authority, imprisonment of up to 3 years and 10% of the project cost. Allottees have also been subjected to some amount of penalties, that if he fails to comply with the order of the authority, suppose in case any dispute, any orders are passed and he fails, then there is a fine which is up to 5% of the cost of the unit. Failure to comply with the decision of the order of the appellate tribunal, imprisonment 1 year or 10% of the project cost. This is the compounding of the offense which has been provided under the Karnataka rules. If there is punishment for non-registration, which we just referenced earlier, you could pay 10% of the project cost, and the penalty for imprisonment has been removed. Punishment for failure to comply with the order of the appellate tribunal by promoter, 10% of the estimated project cost. That was the cost which was supposed to be paid. And as far as the allottee is concerned, if there is a failure by the allotted to comply with the appellate order, it's 10% of the estimated unit cost. Once it is compounded, probably you escape all the other provisions of the criminal procedure code, etc. So that's how the compounding of offense has been defined later on in the rules. All the amounts that are recoverable either on the order of the appellate authority or the adjudicator, it will be like recovery under the land revenue. These are the authorities that the state government is required to set up. We will probably have an adjudicator or a real estate authority. It's called the regulator, and the regulator authority will comprise of three members. One is a chairperson. The other one will be two other members who could either be an administrative or a technical member. And once they are appointed, they will have they will be the people whom you can file complaints. They will have the right to adjudicate within 60 days. The authority, including the appellate authority, have the right to give you interim reliefs under the Act and for all disputes that are there. If there is an order passed by the adjudicator or the regulator, it is appealable within 60 days to the appellate tribunal, which has to be constituted by the state government, which probably will be done. Every bench of the appellate tribunal will consist of a judicial member and two other members who could be either administrative or technical. And any appeal which is filed before the appellate authority, it has to be filed within 60 days with the provision that if there is sufficient cause, there will be a additional time given to the appellate in that appeal. The complaints that have to be filed by any complainant is with the application fee of 1,000 rupees. From what I understand from the authorities, from the chairman right now, who is actually looking after the Karnataka Real Estate Authority, is that even the complaints will be filed and can be filed on the website, and they will take it up once it has been uploaded by you and by paying 1,000 rupees as the fine. As I mentioned, any appeal from the appellate authority, from the tribunal, from the regulator can be filed to the appellate authority. I wish to point out that as far as the appeal which is to be preferred, there are two different, there is a very big difference between an appeal filed by an allottee and an appeal filed by a promoter. If a promoter wishes to file any appeal which he has lost before the regulator, he has to deposit minimum 30%, sometimes 50%, and it could be the entire 100% of the penalty that may be imposed by the regulator before he can file an appeal. That is at the discretion of the appellate authority. But the allottee is not required to pay any amounts in case he wants to prefer an appeal. As mentioned earlier, that the appeal has to be disposed of within 60 days. If it is not disposed of, reasons have to be given for why it has not been disposed of. Any post the appellate authority's decision, the provisions of the Constitution kicks in, and you can file an appeal before the High Court. This is the bar on jurisdiction. Civil courts will have no jurisdiction to entertain any matter which is pertaining to the Act. No injunctions can be granted by any civil courts in the matter which is covered by the Act. And anything which you need to do, including interim reliefs, you need to go to the authority. This is pertaining to the agents. What has happened is even the real estate agents earlier and till the Act came in were absolutely not regulated. We did not know how they would function, what they would disclose, what they would represent. So what has happened is now they have encompassed under the Act any person, and the definition is very wide, that any person who makes one person meet the other for purpose of gain is a real estate broker. And as a result of which, any person who wants to do that kind of business is mandatorily required to register under the Act. Failure to register under the Act also is punishable to real estate. They will probably charge them fines, and that's what will come to. And the real estate agent also is required to ensure that whatever he represents to any member of the public who is buying apartment should ensure that his representation is true to the facts. What has also happened is that by virtue of this act, any developer who wants to engage with the real estate, that real estate agent also needs to be registered. Any real estate agent who wants to sell a project or market a project can only market if the real estate project is registered. The registration for real estate agents is also provided. There are some fees to be paid, they have to give, and the registration is valid for 5 years. These are penalties which have been provided for the real estate agents. Thank you. As mentioned earlier, as you have questions in your mind, we also still have questions. We don't have all the answers. So, I would be very happy if someone has questions and, probably we can discuss and debate it, probably increases our knowledge, your knowledge. No. And I'd be happy if there are anything which people want to ask any questions, want to discuss any aspect of the Act, would be happy to do so.
Purchasing of agricultural land, which is not permissible in Karnataka, must be a peculiar situation for Karnataka, this thing. Therefore, land cost, the delay in purchasing, getting it converted, and then this thing. But for such an eventuality, I did not find anything provided. Did the state government or this real estate people, did they take up the issue with either the state government or the central government with regard to this? That is one aspect. Second is, with regard to these housing cooperative societies who are not constructing the building, who will be only making the layout, the contribution will be by the members, but they are included within the meaning of promoters.
Yes.
Under the Act, would they have made any exception or some sort of changes for those societies? Is there any provision? Within the present scheme, anything can be done. That is second one. Third is, with regard to this depositing of the amount, how it would work out for a cooperative society, whether they can get out of this by increasing their share capital instead of making the payment for the plot cost.
Okay, as far as, I will answer the first question. As far as the agricultural lands are concerned, the conversion aspect, the fees, etc., it's not covered under the Act, but the Act provides that as far as the land cost is concerned, once the land is converted, all the cost that has been incurred by the developer will form part of his land cost. Agricultural land in the state of Karnataka, as everyone knows, is not capable of being developed other than for agricultural purposes unless it is converted. So I hope at least that aspect is clear, that we cannot bring the agricultural land within the ambit of the Act. So there cannot be any development of the agricultural lands. And so hence there is no question of those costs being included for purpose of development of agricultural lands. The other aspect is the cooperative society, which is a burning issue. It keeps coming in the newspapers as far as the cooperative societies are concerned, whether it should be excluded. But I think as far as the Act is concerned, there is no such provision that excludes a cooperative society from the purview of the Act. In fact, the Act has also included any government agency which actually does business in selling plots, which includes BDA, KHB, and all those who actually construct for our society are included. Basically, the aspect is, the ambit of this Act is basically to ensure there is accountability of any person, including cooperative societies, governments, or other agencies, private, individual societies, trust, etc., to be covered by this Act, so that the entire transparency is available to anyone who buys either from the cooperative society or from the private buyers or from government. And hence, as of today, though I know that there has been a lot of representation being done that the cooperative societies should be excluded from this act. The third aspect is with regards to the deposit of the amounts of 70% in the project account. As I mentioned earlier, that whether you increase or decrease the cost of your shares or of your plot, and in cooperative societies you have to acquire the shares, the amount which are collected of that 30% is first released. The 70% can only be released on your completing a particular percentage completion for which the actual cost is taken into consideration and not the projected cost. And hence, increasing or decreasing the values of your land, shares, etc., in my view, will not benefit you, save and except the fact that that amount will continue to remain in that project account, which you cannot do anything about.
Good evening. Good evening, sir. Most of the legislation governing land and the town country planning, etc., is in the state domain. Now, do you do you think that RERA is a transgression into the legislative powers of the state? Because there will be certain conflicts between the town country planning act or the BBMP regulations, the municipal laws that are governing the land allotment or the regulation of the buildings. Now, second is you said the civil court's jurisdiction is ousted by RERA. Now, what about the consumer court's jurisdiction and the competition commission's jurisdiction, which also have adjudicated on these aspects in the past?
Yes.
Thank you.
The first aspect as to whether there is a usurping of the state's right under the constitution by the central enactment. I think this has been debated, and I think as far as this act is concerned, if you look at it from the conflict perspective, this act does not conflict with any of the state acts, in my view. Not a single act is conflicted. Any provision of any act which is required to be complied is mandatorily required to be complied. This act is only to regulate this industry and not to regulate any provisions of the act. For example, sanction of plan, you still have to go to the BBMP in our corporation jurisdiction, or BMRD or BIAPA in those jurisdictions. Any other provisions for conversion is not usurped. Any provisions with regards to this provisions of Karnataka Land Reforms Act, it has not been usurped. So none of the provisions of the RERA, in our view, conflicts with any of the state acts. So hence there is no conflict. As far as the usurping of the jurisdiction is concerned, yes, the civil court's jurisdiction has been taken away. It's not very uncommon. Certain other acts also have provided for that. As far as the consumer forum is concerned, they have made a provision that as far as the ongoing cases are concerned, you have the ability or the discretion to continue with the consumer forum, or when the authority is set up, you have the right to transfer it to the authority. And I think there will be a lot of choices that people will make to move to the authority, because the authority is mandatorily required to adjudicate on a complaint by an allottee or a consumer within 60 days' time. And this act is a specific act as far as the industry is concerned, and it views all aspects in only one direction, that is the real estate direction. So hence, I think most of the people who are in consumer forum will definitely move on to this. And once the new projects come on, then I think consumer forum jurisdiction may not be there, and I think no one would want to go. The other aspect which you mentioned of the Competition Commissioner of India, I just want to make a point which actually I reviewed this and just wanted to point out there is a provision that the authority, if he finds that there is monopolization, cartelization, he can suo motu, make an application or bring that to the notice of the Competition Commissioner of India, and the Competition Commissioner the Competition Act will definitely have the right to view if there is such violation of the Act. So it's not as if it takes away the jurisdiction of the Competition Commissioner. It doesn't take away jurisdiction of any of the state acts. So hence, I think there is no conflict as far as the Act is concerned with any other Act.
Recently, the state government has notified the town and country planning rules, under which
It's not
the draft
notified,
rules.
draft rules.
Draft rules. Now, in the draft rules, there are certain obligations cast on the developers to relinquish certain lands. There are certain obligations cast on the developers in respect of the modus in which the land has to be developed. Now, are they in addition to the one that RERA prescribes? Now, if there is a conflict, now which one will prevail may be the question that...
Can you just point out which provision of the RERA provides for all these things?
No, it does not provide. See,
Yeah,
the
so-
relinquishment is not provided.
No, so the relinquishment is the planning authority's jurisdiction, and hence the new ZR which has been circulated provides for certain aspects of how it has to be released, what extent has to be released, what can be done about it. RERA will only ensure that any developer who has relinquished or used or is supposed to use that particular land will ensure that they will use it in that format. They cannot prescribe, so there is no such conflict at all.
One of the conflict which we found was with regard to the existence of Karnataka Apartment Ownership Act and Owners Regulation Act, which has not been repealed by the state government pursuant to RERA enactment. So what would be the conflict and which will prevail?
In my view, there is no conflict. In fact, the RERA Act provides that the association must be formed in line with the existing act in your state. And hence, in our state, Karnataka Apartment Ownerships Act is the act which has been provided for purpose of making an association for maintenance of the project. So there is no conflict. I don't think there is a conflict at all. In fact, it is actually saying that you must form an association within X period of time in line with the provisions of the act which is applicable to you.
Good evening, sir. I have a question. This is regarding a complaint before a regulatory authority. Can a lottee in a project which is not registered on RERA, like there are a lot of projects which are not even taken off, can a person in such a case go and file a complaint before the regulating authority?
Yes, of course. It's provided that any person who is required to register does not register. If it's an ongoing project, the buyers of that ongoing project have a right to bring that to the notice of the regulator. And I pointed out to you that if you do not register, you can be paying penalty up to 5% and going up to 10%, imprisonment of 3 years.
Okay, sir.
So it's not something which you cannot. And in fact, I must point out to you that in a discussion in an open forum, it was mentioned by during the discussion that the authority also has the right, and in fact it's in the act itself, to suo motu take up if there is any project which is not registered.
Okay, so one more question. Can a third party who's not even related to the project, can he go and approach the regulating authority if there's any violation?
There is no jurisdiction, so hence I don't think he can apply.
Okay, sir. Thank you.
Good evening, sir. My question is kind of general. It's not technical about RERA. So, like, demonetization and RERA came back to back. Like, RERA came in 2016, and 2016 December we had demonetization. So, real estate sector basically contributes a lot to the GDP, and it's a cash-intensive sector. So, like, how is demonetization affecting the real estate sector with RERA also being a part? Like, since both came in 2016, how is demonetization affecting, the buyers and the allottees and promoters? How is demonetization affecting all of them under RERA?
Difficult to answer this question because, first of all, I do not know the impact of demonetization on builders. I do not know how they do their trade. I am a professional who actually does their documents and guides them. So hence, I would not know how it will affect. RERA has nothing to do with demonetization. RERA is only to regulate that industry. So I really can't answer the first part of the question.
Hello, sir. Firstly, thank you so much for your very detailed talk. At the beginning of your talk, you spoke about how the construction industry supports 250 ancillary industries. And while this act speaks a lot about the relationship between allottees, purchasers, and developers, it also does not allow liens to be placed. It goes from take and construct mode to principle to construct and take mode. So it does not also allow liens to be placed on that 70%. Whereas a lot of building and construction work is done through, independent contractors who work on credit and rely heavily on that credit to make ends meet. So how has this affected the, does the Act say anything about the other side of the market? What does it say about it, and how does it speak about that?
From what I understand, what I could gather from your question is that the ancillary industries or ancillary workers, and I mentioned that there are 250, industries which are dependent upon this. Some of them are governed by their own regulations and acts. Like, for example, the labor is governed by the Labor Act. But the RERA doesn't want to govern any of those. RERA only will govern a person who is the promoter. And the promoter, as I mentioned to you, has been defined a person who constructs, causes to be constructed. And it is his obligation to ensure that he gets the construction done as promised under the Act and as per the specifications. Earlier, you would have noticed in several contracts that the contracts provided that there were riots or there was, strikes, then that would be considered as force majeure. The Act has taken away those rights or those aspects of delay to only restricted to those natural calamities. And hence, I think the Act only is concentrating on a promoter who is supposed to deliver. How he delivers is not what the Act needs to go beyond the promoter's promise which he has given in the contract, and how the allottee gets the apartment. So hence, the background or the people connected with the promoter is not governed by this Act at all. Yes?
Thereafter, dispute arises between the parties and the KHB or somewhat. It comes under Land Acquisition Court or the RERA authority.
If there is a dispute between the promoter and the allottee, it will be the RERA authority. If there is a dispute between the land acquisition, between the landlord and the agency which acquired, it will go to the Land Acquisition Act. It cannot go to the RERA Act. These are two different provisions.
Good evening, sir. Sir, one question. You said that civil court jurisdiction has been ousted out as per the RERA. Now, immediately interim relief is required. We will go before the civil court. Once we go before the civil court and after the setting up of this RERA tribunal, can we transfer the petition to the RERA?
You're mentioning that as of today, right?
As of today.
Before the authority. And
Yes.
I would look at it from principle of natural justice. Yes, you have the right to go to the civil court in case of urgency. And thereafter, I'm sure it can be brought into the aspect of the authority. And the authority, including the appellate authority, have also the right to give interim relief. So this could be continued post being transferred. So though there is no such specific provision as how they have given for consumer forum that you can take, for civil courts, in case, because the authority has not been set up, that interim period, I'm sure principle of natural justice will apply.
Can be protected.
Yes, yes.
Thank you.
Sir, good evening. My question has to do with development of layouts by cooperative societies. In most of the cases, what they do is they call an EGM and they pass a resolution for a third-party developer to take up the development of layouts. In such a case, sometimes what they do is they sell the sites to their allottees, and sometimes the developers sell it. So in such a case, who needs to register the project under RERA?
In this case, both need to register, because if both are selling, it is the same issue, same provision which applies to an individual who actually enters into a joint development agreement with the promoter, where he wants to sell his share of the constructed area, and if he wants to sell before the occupant certificate comes, he needs to get registered, follow the same provision which is applicable to the promoter, because he will be then deemed to a promoter. The last slide I showed to you, any person selling or developing and causing to sell also will be the promoter. Hence, both will be required to be.
So, but if the sale deed is made directly with the cooperative society, but then in such a case with the cooperative society, you need to register under RERA?
Yes, he has to register if he wants to sell. The society will have to register it as a promoter to ensure that he sells his site, ensures that he follows the provisions of the Act by virtue of depositing 70% and releasing only after the work is done. So according to me, there is no distinction.
what the Town and Country Planning Act in Karnataka could not do in Bangalore, curbing of illegal layouts. I think, subject to what you say, that this act will curb the illegal layouts in Bangalore, in planning area. There will not be any illegal layouts in Bangalore because of this act in future, because what the Town and Country Planning Act could not do in Karnataka, Bangalore, this act will do.
As far as this act is concerned, this act makes it mandatory. Act makes it mandatory for a promoter, whether he is constructing a building or forming a layout, to comply with the sanction that has been granted. Yes. He cannot start a project, either a construction of a building, commercial or residential, or a layout till such time as approvals are in place. And hence, if you do not have approvals, you cannot have Form 10 registration done. You cannot have those layouts now at all.
All the 20, 30 feet roads
not
are
possible.
gone now.
Not possible.
Bangaloreans should be thankful to the central government for this act.
But I just also want to tell you that the Karnataka Town and Country Planning Act does not allow you to do layouts which you mentioned.
But it was violated. But this act will curb that one.
I think we did not take it up.
Yeah.
We did not take it up. I think it was very convenient.
Yes.
Good evening, sir. The project is developed through JDA. If the project is set to take off, can the owner of the JDA invoke the provisions of RERA?
No.
I have given my land to develop for a developer. He has not yet started for 3 years. In such case, can I invoke the provisions of RERA to adjudicate and get my issues resolved?
No. The provisions of RERA is not available to you. You have the right to terminate it, and civil court will have jurisdiction.
Okay, any dispute between owner and the developer?
Is not covered by RERA. It's the dispute between a promoter and an allottee. So, owner is not an allottee.
Thank you, sir.
If any project which has been registered and not completed, the allottee has the right to file a complaint, irrespective of the fact that the project has not been completed for the next 5 years. So there is no limitation per se. As long as the project is registered, as long as the project is not completed, and as long as the defect liability period is not over, the provisions of the act will apply to the promotee and the allottee and the promoters. So there is no limitation.
Like how in consumer forum we have to file a complaint within 2 years of the cause of action, whatever. So there is an agreement and it has been allotted, and he has not been allotted, the sale deed has not been registered in his name. So there is no limitation as such, he can file at any time?
Anytime, as far as the cause of action is a reason, you can file it before the authority, and authority actually must complete it within 60 days.
Good evening, sir. Can the authority register the apartment without the promoter obtaining an occupancy certificate?
No, authority is not a registering body. Authority is an authority where the project has to be registered. So the authority which we are talking about, RERA, is not a body where you can register your sale apartments.
So if the sub-registrar registers an apartment without the promoter obtaining an occupancy certificate, then...
As far as the RERA Act is concerned, the registration is post the occupation certificate. So it's actually... earlier, I know people were registering before OC, etc., but now it's mandatory that you have to get an OC.
Thank you, sir.
There is a new concept of title, which I found. New concept of title. The title of a property in the usual business course or a business model used to be vested with the constructed area and the undivided share of land being vested with an allottee. Now we have a concept where the apartment as the carpet area vests in the allottee by means of transfer of title. There is a vacuum insofar as the exclusive usage areas is concerned in the nature of balconies, number 2. The third thing is we have the common areas and the undivided proportionate title vested in the association owners. That's called as the association of the allottees. We have understood in the jurisdictional concept that land means whatever is attached to the land. That is what is meant by land.
Immovable property is something which is attached to the land.
Which is attached to the land. Now we are introducing a new concept to the concept of land, where the title to the immovable property vests in the association of the allottees. And there is a title which in the carpet area vests in the allottee. And there is another vacuum. I do not know in whom it vests. There is a common area. There is this usage, the balconies, where they say it is not part of the area which will be sold or part of the conveyance. But I am entitled for exclusive usage, but I do not know in whom the title of this property vests. So this new concept which is sought to be introduced under RERA, how does it gel well with the existing provisions under the Transfer of Property Act, because land essentially means the building attached to it. Unless I have an undivided share, unless I have a peg to hold, how is it that I am entitled to hold a carpet area in a building?
I just want to explain to you that this RERA Act is a central act. It applies to the whole of India. What you just read, I think we need to read it a little more carefully. What you just read applies to places where the cooperative societies are formed, where the land gets vested in the cooperative society, including the common areas, and the constructed area is vested with you by virtue of the shares which you acquire. As far as our state is concerned, I'll come to your carpet area a little later, because the balcony area. As far as our state is concerned, the concept here is undivided share in land corresponding to the FAR that has been consumed, which will entitle you to the constructed area which you paid for under the construction contract, and hence by virtue of paying for the construction you become the owner, and by virtue of every person in an apartment building being conveyed the undivided share, which also includes the proportionate share in the common area, which gets formed in an association under the Karnataka Apartment Ownerships Act. That association then governs the common area which belongs to each of the flat purchasers, and hence it does not stand in vacuum, as you mentioned. As far as the carpet area definition, if you're concerned, the carpet area definition has been given to ensure that the measurement which you get for the purpose of utilization is disclosed to you by the promoter. It doesn't mean that the balcony area, which actually is also included in the FAR in terms of our building bylaws, which gets sold to you by virtue of the undivided share, the only purpose is to show you the carpet area definition, is to say this is the livable area and that is the carpet area which is excluded for purpose of calculation of the carpet area. That doesn't mean that the balcony which is built into your apartment is in vacuum. So hence, in my view, process of learning will always go on. In my view, the definition of the carpet area, the balconies have been excluded only to ensure that the buyer knows what is the area in which he can lay a carpet, so that he knows the difference between the carpet and super built-up area. It falls under. For example, in Maharashtra, it's the MOFA, which allows an allottee of the apartment under a share transfer to transfer his shares. That also requires registration under the Registration Act. That also requires stamping to be done. And that by virtue of this transfer of those shares and becoming member of the society, you become the owner of your flat by the shares. And by virtue of becoming membership of the society, you become owner of the common areas. That's what I understand. I don't think I can go beyond this, because I can't threadbare the whole thing right now. But that is what I understand. So it's not as if it will remain in vacuum, in my view.
Hello.
As regards the exemption of the ongoing projects, where one of the things is 60% of the sale deeds have been done, it is exempted. Now the 60% indicates the number of the units or the extent?
The 60% of the entire apartments that have been constructed. So if it's 100 apartments, 60 apartments.
For example, if there is 100 apartments, let's say 100 square feet is our total extent of the...
No, it's not the question of square feet.
100 apartments. What if the 40% of the apartments are big and that constitutes 60% of the total approved extent?
I understood, but I don't think I can interpret that right now, because it just says 60% of the purchase of the apartments. That's what it is.
Especially when it comes to the layout, You know, there is
no layout, that 60% is not applicable. The layout applicability is the first exemption which gives to say that the layout, once it is completed and you've handed over all the civic amenity sites, roads, etc. to the authority, then it's deemed completion. Then there's no question of registration.
So
the
for
registration of the apartment applies only to old projects which I mentioned earlier, that if the 60% conveyance of the apartments have been done, common areas have been handed over to the owners, then you may not fall within the applicability of this act.
So it is the number or the extent, is it clear?
The number, I feel, that is what it is. The number. Say for example, you have 100 apartments. If 60 of the apartments are done, then probably that registration. Then even if the 40 is more than the larger apartments, I mean, I can't interpret it now, but my understanding is 60 apartments.
So let's consider a scenario where the promoter or the developer with due diligence is continuing with the construction. Now a third party approaches a court of competent jurisdiction and obtains a stay, according to which the promoter is duty bound to stop the construction. Now the time for which the stay operates, would it be included or excluded in the time that is taken for construction? Because if it is excluded, would it not be a way to circumvent the provisions of the Act?
The Act does not permit such an exclusion. But I must just tell you that if you look at it, the discretion is with the authority to whether grant you time on that aspect. So if you read the provision of that particular powers of the authority, it says it has the discretion to review the delays. But as far as the Act is concerned, there is no provision which allows you to extend your time if there is an injunction or a suit pending. There is no such provision.
But the promoter is bound to...
Yes, the promoter is bound by the time. Bound by the time and is bound to stop.
And also bound to stop, yeah.
It's his obligation to get the injunction vacated. The Act is very silent. I'm sure there will be a lot of debates because there will be debates on the basis that, well, I've applied for the occupant certificate, delay to get occupancy is not mine. All this is going to come about. The aspect, I think, of this litigation, I will just, from what I understand, would be the thought process of the framers of the Act is that it's very simple to make someone file a suit and get an injunction. So they are probably getting those aspects out. They're making it very transparent. That's probably, I'm sure there are genuine cases too, right? Okay, but that I think one has to see it as in when it comes.
Hello, sir. With respect to registration of real estate agents, I have two questions. One is there are two categories under the registration of real estate agents. One is individual and the partnership firm or a firm or proprietorship. So how different is an individual from a proprietor?
A proprietor is an individual, individual is a proprietor. I understand there is a debate going on that if you have a proprietary concern, you fall in the category of payment of 2 lakhs of rupees.
Exactly, sir.
I understand that. I know that debate is going on. We'll await a clarification which comes from the authority to, clarify that a proprietor is an individual.
Okay. And then my second question is under the area of operations, in an application for the registration of real estate agents, we have to disclose the area of operations. Say suppose Bangalore North, if person has to register under Bangalore North, can he not sell a property in Bangalore South?
He can. The registration applies to the whole of Karnataka. You cannot sell a property in Maharashtra, or you cannot broker a property in Maharashtra, but you can broker property. That's the clarification is already there.
Okay.
It's been given.
Right. Thank you, sir.
So what happens to the landlord here? Will he come under the RERA Act? Because I have an agreement with the landlord. So what happens if the project stops? I don't approach the developer here.
So if you are a landlord, given your property for development, I would understand, in form of either development as a joint development and as the either by revenue share or by constructed share, right? There are two aspects. If it's a revenue share, then you don't have to register it. If it is an area share, then you need to register it if you propose to sell. As far as the violation is concerned, the violation will be against the promoter and not the landlord, as long as the landlord is not a promoter. That's my view.
So then the remedy for landlord?
No, remedy for landlord against the promoter is not under this act. You will have, if you have delays, penalties, compensations, action in tort, etc., you take it to the civil court to sue the promoter.
What happens with the allottees, sir?
Allottees are governed by the act. As we just mentioned, the gentleman just mentioned that if the promoter runs away or the promoter doesn't complete or is delays, there is a provision under section 7 and 8 that the authority can take over the completion of the project. I do not know how it will be happening, but that authority is available. They have also said that the authority will give to the existing buyers and the allottees the first option to take up the development and completion, which probably makes sense because they would be the most interested party in completion. So they would then complete it.
What if an allottee has an agreement with the landlord and not with the promoter?
No, if the agreement is with the landlord, then the landlord is a promoter. I explained to you earlier that if he proposes to sell prior to the occupant certificate, he comes into the same shoe as the promoter.
The definition of promoter, which says a person who constructs or causes to be constructed, would it include within its ambit a landlord because he's giving his land for it to be, causes it to be constructed? Would that also mean that he comes under?
It does, because once he starts selling, then he becomes the promoter. So that is what he's caused the construction of his share and he wants to sell. The clarification which we have got right now is that if the landlord wants to sell, he has to register. If the landlord doesn't want to sell till the OC, he doesn't require to register. That is what our understanding is today. And this is purely from the point of view of all the clarifications which keep coming from time to time. It may change later on, I do not know. As long as the clarifications keep coming, we'll probably know exactly how the detail works.
So at what point in time should he determine whether he should go for registration or not? When he intends
As
to
soon
sell
as
it?
he wants to start selling his apartment before the OC. Before the OC. Because any project which gets an OC is completed project, and hence he doesn't have to register it.
What if he has a last minute change of mind?
He registers it.
No. I'm looking at the other way around. He didn't want to sell it before, but then he wants to sell it.
Before the OC.
Correct.
He registers.
At that point in time.
Yeah,
There
he
won't be
can.
any delay from his part.
No. He can
Because the
register at the
commencement-
time when he wants to sell.
Because the commencement certificate has been long issued back.
Commencement certificate is purpose of registration of the project by the promoter.
That's exactly my point. Doesn't he come under the definition of promoter as per this definition?
I do understand the complexity and the confusion which is there, but I'm only saying from the point of clarifications which we have received to say only when he wants to start selling the landlord will he become the promoter.
Good evening, sir. Here. Sir, my question is with regard to ongoing projects. Thing is, as everybody is telling, Rule 3 of Karnataka Rules, RERA Act says that 60% of sale deed is already executed that do not fall under the ongoing projects that is being excluded. Only that criteria is taken into consideration, or apart from that, CCOC is also compulsion with regard to 60% of sale deed. All three together is taken into consideration, or only 60% of the sale deed is taken into consideration?
Only 60% of the sale deed is taken into consideration.
If that
As
is-
far as the OC is concerned, there is another exception which has been given, where you have applied for an OC and you have got a certificate from a competent agency that is provided under the Act, then you did not fall under the registration of the your project under the Act.
Oh. How about the projects not having the OC, and sure we won't be getting OC? This is a common issue going in Bangalore. For sure we won't get the OC for the project. There are so many projects. How about the allottees in those projects?
If 60% of the apartments are sold in that project and the common areas have been handed over to the owners or the occupiers of that building, then it is excluded. I will tell you the logic behind that so that you will understand immediately. There are historical buildings in Bangalore which do not have the OC, but the developer has conveyed the property. Most of the times 100% is conveyed, but the exception given is 60%. So as a result of which it doesn't clutter up the registration and doesn't serve any purpose, because this may be 10 years old and 15-year-old project, and hence that was the logic to exclude in case where 60% is sold and conveyed by registered sale deed, and the builder is handed over the association to the common areas, then he doesn't require to register. The criteria is the moment he has not handed over and he holds on to that, he will fall within the provisions of this Act.
Okay, sir. But how about in continuation that even if we apply OC for today, we won't get? But
That I do
60%
not-
of sale deed is not been done.
No, I do not know whether he'll get the OC or he doesn't. That's not the aspect which probably the exception says that.
Okay, sure. Thank you.
Hello, sir. I have two questions for you. Does someone who is responsible for joint venture come under a real estate agent? Does he have to register for RERA?
Sorry, I
Who's
didn't understand this
responsible for joint venture?
No, I didn't understand this at all.
Okay. Let's say I'm a real estate agent. I am not selling a plot or an apartment. I'm responsible for the project to take place on a whole. I'm making the developer meet the landowner.
Yes, you'll fall under the definition of real estate agent.
Okay. And second question is, sir, in case of, let's say, a developer takes up a project, he's not able to complete, let's say, because of bankruptcy, and another developer comes into the project, so this developer can exit. So what's the procedure of the new developer coming in?
If it is an ongoing project and a project which has been registered under the RERA, then for purpose of assigning the rights of a developer, he requires consent of 2/3 of the purchasers in the project. So hence, whether he becomes bankrupt or otherwise, if he wants to assign his rights, he needs to take consent of 2/3 of the purchasers at that moment.
But if he's not able to complete the project on a whole,
If he is not
needs
able to
exit.
complete the project within the time which he has given, then the provisions of section 7 and 8 would apply. Then the registration would get cancelled, and the authority will be able to take over the project, as we mentioned earlier. And if they can complete it, they can complete it.
Thank you, sir.
Thank you very much for patient hearing. You'll excuse me if I have not answered your questions. You'll excuse me if I have made a mistake, because I am very sure that this is also my learning process, to tell you frankly.
Thank you, sir. Your talk has definitely helped us understand the finer nuances of RERA and broaden our perspective. Even the question-answer round was invigorating. It helped in fruitful exchange of ideas and covered a wide range of topics. Moving on, ladies and gentlemen, we have with us today another eminent personality, Mr. Rajiv Gowda, MP Rajya Sabha. Welcome, sir. We are truly honored by your presence. We request you to give us a brief insight on debates and discussions that were held in Parliament and the actual history behind the enactment of RERA.
Mr. Anup Shah, Mr. Baswaraj, Mr. Shivaram, who is left, and my advocate friends, I'm here to plead guilty jointly and severally with my Lok Sabha and Rajya Sabha colleagues for inflicting this very complicated piece of legislation on you. But it looks like it will keep every one of you busy and employed in a very, very constructive way going forward. I have come very late, and I wish I had another clash, I had another function at this very same time, but I wish I had been there through the entire discussion and presentation of Shri Anup Shah, because that would have given me a very, very good sense of how the legislation that we pass in Parliament actually translates on the ground. Now, for me, I've been in Parliament for about 3 years now. I had a chance to be a member of the Select Committee of the Rajya Sabha, which actually refined and improved, in our view, the Real Estate Regulation Act. And we took this job extremely seriously. And our chairman, the late Anil Madhav Dave, was promoted to a minister partly because of the excellent job that he did in bringing all the party members of this committee together, to the efforts that he took to ensure that we went around the country, consulted numerous stakeholders, discovered the complexities, the differences between how Bombay and Maharashtra does apartments, how Karnataka does it, how Delhi and Noida do it. There's so much complication out there. And I'm also a member of the Rajya Sabha Committee on Subordinate Legislation, where we actually look at whether the rules that have been framed under the legislation actually match our intent, are working the way they're supposed to. Now, I won't take very long. You've already been here a very long time. But basically, what was the intent? This bill saw its origin during the UPA years. Selja and Ajay Makan were the ministers who brought it forward, and then Venkaiah Naidu under the UPA took it to completion. Now, the basic thrust was that construction, that the real estate sector, I shouldn't say construction, the real estate sector is growing at a very, very rapid pace, that there is a lot of inequality of power between builders and home buyers, and that it is to the disadvantage of home buyers that they are getting essentially ripped off by builders and developers who take their money, delay projects, use the money for further land banking and other stuff, and as a result, leave home buyers in the lurch. So the first and foremost motivation was, let us get into this industry and let us regulate it with the aim of ensuring that nobody is taken advantage of. And in this context, it's actually, from a political economy perspective, it's interesting that a bill of this sort actually went through, because there are many builders or colleagues of mine with builders in Parliament, or colleagues of mine with interest as in real estate firms. So it was, to me, quite fascinating that they too went along with many of the fairly stiff provisions that we brought into the passage of the Act. However, what ended up happening, I mean, for example, I'll give you my one attempt at making a strong amendment. See, one of the things that I have noticed, and in casual conversations, there is a lot of discrimination in the real estate sector in terms of who apartments are sold to. It's much worse in terms of who apartments are or houses are rented to. That's not under the purview of RERA. But even in the context of this law itself, normally I've heard people say, oh, I do not sell to this community, that religion, things like that. And that's, if you are out there advertising and you're selling, you shouldn't be able to discriminate between one Indian and another, right? So I tried to move an amendment. In fact, it was on the record. But then the minister basically asked me to withdraw it, saying that he would ensure that it would be in the rules. Well, when I actually look at what has passed since then, and this is something that I've raised in a special mention in Parliament, they've left it to the states. And some states have included this clause, some states have not. And the purpose of the minister's assurance, to me, was not really fulfilled. And I'm worried that, that essentially there will be more discrimination going forward. Well, that was just my one rule, but that is my attempt anyway to try and change things for the better, in my view. But the basic experience there was that a lot of discretion was being handed over to the states. And so there is tremendous diversity in the way this law is actually being implemented. Different states and their rules, the pre-existing conditions and legal frameworks in these states, all of these are coming together to create, unique situations across the country. In some sense, this is not really what many of us intended. We would have wanted, for the sake of the real estate sector itself and its growth, much more congruence across states, possibly to have a legal framework that would enable people to go out there and develop across state boundaries. After all, housing especially is a great need, and there's a huge gap between what we are able to provide, both in the public and private sector, and what's actually required there. Anyway, so the basic thrust has always been that we want to take care of the home buyer to ensure that they are not exploited. But if you look at where we draw the line, we say what, 5,000 square meters, or what is that cutter? 500 square meters, yeah. It's been a while since I looked at the details. Anyway, so the point is that the most vulnerable home buyers are those who buy in projects which are below that. And this is something I mentioned in my speech, that actually, because of administrative convenience, not wanting to impose bureaucracy on even the small builder or the small project, we have said we will not bring that under the purview. But in some ways, we have left the most vulnerable high and dry. And so that is something that we need to think about going forward. Anyway, I don't have any answers of the kind that Mr. Shah was able to give you. And I'm just here to say I'm so happy that Daksha Legal is organizing these kinds of events, and that everyone's getting a chance to contribute, to engage in the discussion. And if Daksha Legal would be able to send us a set of clarifications and questions, I can certainly pass it on to the Urban Development Department and others to ensure that in the course of time, this law gets refined and its purpose is served. Thank you very much for giving me this opportunity to be here with you.
Thank you very much, sir. As you can see, there are seminars and seminars on RERA, but what makes this seminar a sui generis is the participation by two eminent persons, one in the legal perspective, another one from the political perspective. When I say political perspective, from the point of view of the member of the Rajya Sabha who actually participated and contributed to the emergence of this social beneficial legislation. Now, it's my bounden duty to offer thanks to each one of the volunteers and participants who made this function a tremendous success. I start with Mr. Anup Shah. They say that a busy man has time for everything. In the busiest schedule, he has devoted almost half of his day and a complete evening to participate and enlighten us. On behalf of Daksha Legal and on behalf of each one of you, I convey my heartfelt thanks to Mr. Anup Shah. And the icing on the cake from Sri Rajiv Gowda, who MP from Karnataka, who enlightened us the political history behind the legislation. And I sincerely, and on behalf of Daksha Legal, and on behalf of each one of you, convey my regards and my heartfelt thanks, sir. For this seminar itself, I created a separate group, WhatsApp group called RERA group, and there were several volunteers who dedicated their time and energy for the purpose of inviting the guests and contributing their immense to the successful functioning, holding of this seminar. I will only name few in the alphabetical order, with your permission. Mr. Amog Masur, Mr. Arvind Kamath, Mr. Bharat Keshavamurthy, Srimati Chitra Kalaya, Mr. Chamraj, Mr. Devaya, Mr. Kiran, Mr. Gautam, Mr. Ajay Javali, Mr. Manjunath, Mr. Parmesh. He is not a lawyer, but he works in Kirloskar, and he is also one of the most successful agent of the Life Insurance Corporation. He took special interest in making this function a successful one. Mr. Parshu Shetty, Mr. Praveen, he is a part of this India Legal Organization. He got this RERA Acts, which you can see printed at the most reasonable prices. Mr. Rohit Kukreja, my colleague, Srimati Sahana Pai, the Master of Ceremony, Mr. Santosh, Mr. Sandeep, Mr. Vishwanath, Mr. Yashas, Mr. Lokesh, who printed these cards, Mr. Praveen, and most importantly, my driver Sunil, who got this banner printed. And I thank each one of you for having spent considerable time and energy in making this function a huge success on Kumarakrupa Road. So I request each one of you to participate in the oncoming conferences on different topics. So thank you very much. Have a great evening and a great weekend all.